I wanted to discuss this whole timing advance situation and Sy Ray's affidavit because I personally do not believe that the state has the timing advance records for Bryan Kohberger for November 13th of 2022. Now, originally I did believe they did, but now that these documents have come out, I don't believe they do. And I think Sy Ray is making assumptions in his affidavit. And there is something he didn't mention in his affidavit that just makes me believe he's blowing hot air. Okay, we're starting with the state's motion in limine regarding AT&T timing advance records. And the state is not wanting the defense to be able to mention the timing advance records. So it says the state brings this motion based on defense counsel's repeated references to the alleged existence of AT&T timing advance records related to defendant's cell phone. See defendant's supplemental response regarding expert witnesses, Defendant's Exhibit D11B, page 49, yada, yada, yada. And they go on to say the state has been advised and will offer documentation and or testimony that AT&T records are produced by their Global Legal Demand Center, GLDC. AT&T GLDC did not begin producing timing advance records until May 2023. All records for the defendant's phone were obtained from GLDC in December of 2022. The state intends to supplement this motion with additional information from the FBI and or AT&T prior to the hearing on this motion on April 9th, 2025. Any statements or inferences by the defense counsel or their witnesses that there is additional evidence that could have been provided or was not provided is a mischaracterization of the evidence and should not be allowed. Under IRE 403, any probative value of such evidence is outweighed by the danger of misleading the jury, undue delay, and waste of time. For those reasons, the state requests that the court issue an order in limine prohibiting the defense from making any reference to the absence of AT&T timing advance records for Bryan Kohberger. So they're saying they were not able to obtain those timing advance records, and the defense should not be able to bring that up at trial because the defense is claiming that the prosecution really has those records. So now we go to the defense's objection to the state's motion in limine. And it says, the state motion seeks to prevent Mr. Kohberger from confronting, through a full and fair cross-examination, a portion of the case. The state seeks Mr. Kohberger's silence on records produced by AT&T timing advance, TA records. The state's motion informs the court that TA records were not produced by AT&T Global Legal Defense Center until May of 2023. Mr. Kohberger agrees with that claim. However, that is only partial information. The state is misleading the court in its motion by what it leaves out. So I highlighted this. What the state is not saying is that the TA records existed at AT&T in November and December of 2022. The state has to know this to be true because in April of 2024, the state produced the actual records from AT&T for cell towers and individual timing advance records for 2 of the 4 deceased and 1 for a person who had been a person of interest at the beginning of the investigation, as well as over 3,800 people on the cell tower. These records were from November of 2022 and were produced in discovery to Mr. Kohberger in 2024. It is accurate that the AT&T Global Legal Demand Center did not produce TA reports to law enforcement in 2022. The TA reports from AT&T GLDC were not available to state and local law enforcement until June of 2023. However, the existence of these reports in this case is direct evidence that these records could be and were provided to law enforcement by AT&T prior to the production through GLDC. As such, Mr. Koberger's AT&T TA report from 2022 would not have been provided through AT&T's GLDC. AT&T had TA reports prior to their availability through GLDC. The state is attempting to say these reports were not available until GLDC produced them, and it is nothing more than asking the court for permission to hide the state's failure to disclose Mr. Koberger's AT&T TA report. Depending on how far back the report goes, it will contain exculpatory evidence that will partially corroborate Mr. Koberger's alibi. Mr. Koberger will provide evidence, testimony, and argument to support his claims that the state misrepresents the eligibility of the timing advance records. So then they go on into a background, and they say that Mr. Koberger's timing advance records are different than the other records provided for discovery. The records are location data and that are accurate in determining the location of the cell phone. TA, the timing advance, is a term used in the cellular industry relating to measurement of time. Okay, blah, 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 blah. I'm going to let you pause and read that because this is all the technical stuff, and it's not really pertinent to the argument that's being made. So it goes on to say AT&T was the last of the major providers in the United States to produce TA data for law enforcement. The first TA reports AT&T provided to law enforcement were the result of a software program utilized by AT&T from a third party, Viavi Solutions. Viavi Solutions offered a software solution known as Aries OGEO. In using the Aries OGEO software, AT&T was able to create and produce timing advance records for law enforcement, but due to the pricing of the software, it was at a great expense. As a result, only certain law enforcement agencies were provided access to these reports. The FBI has been the primary agency given access. The timing advance reports were not common, nor were they created in the normal AT&T ecosystem. Thus, TA reports were not accessible to the GLDC personnel within AT&T. The FBI utilized a different legal compliance unit within AT&T to access these records. That legal compliance unit is separate from the GLDC. When these reports were first made available to the FBI, it was draped in secrecy. As a result, there is little documentation to rely on when dealing with early AT&T TA reports made available to the FBI. And I highlighted that because it's basically talking about how it started out in secrecy for the FBI only. AT&T developed a new system outside of the Aries GEO system to produce these records at a fraction of the cost. This cost reduction allowed AT&T to provide these records to state and local law enforcement. As a result, GLDC was given access to the timing advance reports in May of 2023, but began providing them to state and local law enforcement of June of 2023. This distinction is that AT&T TA records were available only to select law enforcement, specifically the FBI, well before this internal change. Mr. Koberger is aware of the fact that the AT&T GLDC did not produce TA reports in 2022. There is no doubt any representative from AT&T GDLC or GLDC will testify to this fact. Mr. Koberger does not contest this claim. The state is also aware of this, as they did not obtain the current AT&T TA records in their possession through the AT&T GLDC. They had to use the FBI, who went through a different legal compliance unit within AT&T to obtain these records. So I highlighted that because that's important as well. At the onset of this investigation, detectives with Moscow Police Department began obtaining call detail records as part of the investigation. In doing so, they heavily relied on assistance from Special Agent Nick Balance with FBI CAST. This is the first documented email exchanged on November 15th, 2022. Detectives Lawrence Mowry and Brett Payne were tasked with writing search warrants to AT&T for a number of different requests. On November 15th, 2022, Detective Mowry requested verbiage via email from SA Balance in reference to the AT&T records. The email string that was produced by the state in discovery contains a very clear account of SA Balance's knowledge of AT&T TA being available. SA Balance's email to Detective Mowry states, subject, regarding AT&T tower dump PDF. Nilos became a location database of record, or Loc de Bor, a little while back. List that and timing advance, since both are applicable with them now. Nick Balance. In reviewing this email, there is no doubt that the email in reference is to AT&T, and it is referenced in the subject line. Additionally, there is an attachment with the email chain that contains the words warrant AT&T. Detective Mowry then forwarded SA Balance's email to the prosecutor, Ashley Jennings. Objection to state's motion in limine AT&T records Exhibit 1 email chain. Detective Mowry was informing Prosecutor Jennings of availability of AT&T TA reports and requesting it be added to the warrant. In reviewing the AT&T search warrants that were produced over the next few days after this email chain, all of them contain specific verbiage requesting AT&T TA reports, just as recommended by SA Balance. While the above reference email chain is clear as to the existence, availability, and knowledge of availability to the state regarding AT&T TA reports in November 2022. In July of 2024, Mr. Koberger received from the state AT&T TA reports from 2022 in reference to this investigation. These TA reports were not for his phone. The state turned over 3 separate AT&T TA reports. All 3 reports contained AT&T TA data from November of 2022. In the early phases of this investigation, law enforcement identified 3 AT&T phones of interest. 2 belonged to the deceased, and the 3rd belonged to a person of interest who law enforcement was investigating as a suspect. Detective Mowry authored an affidavit in support of a search warrant to AT&T issued on November 16, 2022 that demanded the AT&T TA records for these phones. All 3 TA reports were produced by AT&T and are currently in the state's possession. The TA report the state disclosed on other phones is what Mr. Koberger has sought relating to his own phone record. He requested the report through discovery and during a motion to compel. Mr. Koberger is aware and will provide testimony to support that the AT&T timing reports currently in the state's possession were not provided to the state by the AT&T GDLC. The reports were provided through another compliance unit within AT&T through the FBI's close relationship with AT&T. Mr. Koberger posits that relying on GLDC stating they did not provide TA reports in 2022 misses the issue at hand. Throughout this discovery process, the state has provided different explanation about the TA report availability, but has always claiming it was not in their possession. The states obtained search warrants in December of 22, where the state sought AT&T TA reports for Mr. Koberger from November 2022. The search warrant for Mr. Koberger's phone data contains identical verbiage that was used in requesting the TA report warrants issued for other AT&T phones in November of 2022. The same process of serving the warrant was also followed. Moscow Police Department obtained a warrant provided to the FBI SA Nick Balance, who then provided it to AT&T. This exact same process, which resulted in TA reports being produced in November, was reported in December. Objection to state's MIL, TA record, Exhibit 2, search warrant, AT&T. The second AT&T warrant contained a document titled AT&T Mobility Carrier Request form instructing AT&T to provide the TA records for the past 7 days as available. Objection to state's MIL, TA records, Exhibit 3. Mr. Koberger has sought the TA records related to his own phone and litigated the issue. During the course of litigation, the lead detective testified he had seen Mr. Koberger's timing advance records. Mr. Koberger has documents produced with such warrants that instruct AT&T to provide timing advance data. Discovery documents contain emails about including that request in the search warrants because it was available. Mr. Koberger provides those documents as exhibits. Conclusion: Mr. Koberger has a right to confront evidence in this case against him. His constitutional protections mean he must be afforded a full and fair opportunity to cross-examine the state's witnesses. AT&T TA reports are available. The state has produced the reports that were prepared before GLDC and produced them for law enforcement. TA reports relating to him exist, yet the state has not produced them. The state now seeks to limit cross-examination and their lack of disclosure by hiding behind half-truths. Mr. Koberger must be allowed to explore the state withholding the evidence. Okay, so did you catch in there that, yes, the state did get timing advance for other people, but they had to get them through the FBI. The state could not get them in 2022 through their own warrants. SA Balance had to forward those warrants through the FBI. Now, what we will find out in the upcoming documents is the FBI had a 7-day retention policy. So anything requested outside of the 7 days could not be received. The timing advance records for the two deceased and one of the suspects were all requested within 7 days of November 13th, 2022. That is why they were able to receive them through the FBI. And this becomes important as we go along. Okay, so here we go with the state's reply to the defense's objection. It says, timing advance records refer to the data that is used by providers to estimate the location of a mobile device. The collection of this data is necessary for a cellular network to work properly. Carriers do not retain this data indefinitely. That is a key phrase. Regarding AT&T, before June 2023, AT&T retained timing advance records for 7 days. Those records were not routinely provided in response to legal demand prior to June 2023. After June 2023, AT&T started providing these records pursuant to legal demand and began retaining timing advance records for 13 months. So prior to June, it was 7 days. In this case, the homicides occurred on November 13th, 2022. Brian Koberger was identified as a suspect on December 19th, 2022. Search warrants for his AT&T records were executed on December 23rd, 2022. At this point, timing advance records were not available for Brian Koberger's phone to cover the relevant time period, November 13th, 2022. Despite the defendant's repeated assertions, the fact of the matter is that AT&T did not provide timing advance records to law enforcement for Brian Koberger's phone. The state is attaching affidavits from AT&T verifying that the state did not receive timing advance records for Brian Koberger's phone. See State's Exhibits S1 and S2. Based on the above statements or inferences by defense counsel or their witnesses that there is additional evidence that could have been provided or was not provided is simply not correct and should not be allowed. Under IRE 403, any probative value of such evidence is outweighed by the danger of misleading the jury, undue delay, and waste of time. For these reasons, the state requests the court issue an order in limine prohibiting the defense from making any reference to the absence of AT&T timing advance records for Brian Koberger. So they are stating it in this document. It was 7 days when the FBI tried to get it because it was past the 7 days from November 13th, 2022, which would have been November 20th, 2022. They were not able to get the timing advance. It doesn't exist. Okay, the two affidavits state the same thing basically, except there was two different date ranges, but I highlighted the portion where it says AT&T did not provide timing advance records for phone number 509-592-8458. Timing advance records were only available if requested within 7 days of the specified time frame. Timing advance records were not included in AT&T records responsive to the reference search warrant because more than 7 days elapsed between November 13th, 2022 and the date of the search warrant, December 23rd, 2022. And this was attested to by Stephen Gordon from AT&T. And here was his second document also saying the same thing about the second search warrant. So the defense responded back with the affidavit of Sy Ray, and we're going to read this. So he says, State of Arizona, County of Maricopa, I am an adult over the age of 18 and have personal knowledge of the facts set forth in this affidavit. I have been working in the field of call detail record analysis for over 25 years. I became a certified police officer in the state of Arizona in 1996. I worked with my first set of AT&T records in 1997. I spent nearly 20 years in law enforcement in the primary role of detective. I've worked hundreds of death investigations and consulted on over 1,000 homicide cases. Blah, 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 blah. Okay, I'll let you read through that. Then he talks about how he started his own company, ZX, that created software for law enforcement to map and analyze. Now his software is called Trax. Moscow Police Department does not use Trax. The FBI also doesn't use it. So if you hear somebody saying that every police department uses it or that the FBI uses it and that Sy trains them, no. He only trains the departments that ask him to come train them on Trax if they use it. And the FBI does not use it. Let's see. In addition to his law enforcement experience, he has instructed classes. So he's talking about his experience instructing the classes on the cellular data. Through my work in this discipline, I am regularly consulted by the prosecution on investigations around the world. Okay, blah, 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 blah. So now we'll get to some of the meat of this. He says, I have worked extensively with timing advance data from the cellular phone network providers over the past 15 years. I have testified to the use of timing advance data numerous times. I have created and taught hundreds of classes on this subject matter to law enforcement. I'm extremely familiar with the type of timing advance records available from U.S. cellular providers, their retention periods, and the legal process to obtain those records. Timing advance records are maintained by cellular network providers that provide time measurement. This time measurement refers to the amount of time it takes a radio signal to travel from a cell site to a mobile device and back to the cell site. Given that this signal travels at a known constant speed of light, it is possible to use the measurement to determine the distance to the mobile device from a known cell site. When multiple cell sites record timing advance data in short periods of time, it is possible to utilize trilateration to determine the location of a mobile device. The use of timing advance data in this manner is one of the most accurate ways for law enforcement to locate a mobile device. Given these records are available in a historical context, it is possible to conduct an analysis of timing advance data to pinpoint historical locations of a mobile device at a given date and time. It is also possible to determine routes of travel, stagnation, and when a mobile device is powered on and off. As a result of its accuracy, requesting timing advance data has become a standard practice for all law enforcement in the United States and is regularly requested through legal processes relating to criminal investigation. So then he goes on to talk about AT&T timing advance. In August of 2021, I was approached by an FBI special agent. So this was August of 2021. I've highlighted this. So you don't get this confused with 2022. A special agent to assist in analyzing a type of record set identified as AT&T Timing Advance Report. And it was the first time I was made aware of this type of data from AT&T. Upon request, I can provide the date, time, location, and FBI agent I assisted with the record set. Okay, well, not sure why that matters. As of the year 2021, AT&T had not officially released a timing advance report to law enforcement. Therefore, the ZX software program did not yet support AT&T timing records. Well, that's his program. And like I said, Moscow police doesn't use it. As a result of this interaction with the FBI, I obtained a copy of the timing advance report from the special agent and forwarded it to our software engineers to write code within the ZX system to support future uploads of this timing advance report format. The next day, I was informed by the special agent that the AT&T timing advance report was not supposed to be released or viewed outside of the FBI, and that an individual requested I return the report and not have any software developed to support the data they had shown to me. I did return the report. However, due to the interaction explained here, there is a paper trail documenting the facts of this interaction. So interesting. Basically, right there, he's saying it wasn't supposed to be shown to anyone outside the FBI, so not regular local law enforcement, and they didn't want him updating his tracks program, which is used by local law enforcement to support that data. So because of that interaction, he says, I have firsthand knowledge that AT&T was providing the FBI with timing advance reports prior to August of 2021. Yeah, and I'm going to say this isn't in dispute. It's not in dispute that the FBI can get timing advance. So that's why some of this is just like, this isn't really relevant to the argument in here, but AT&T legal demands. During my career working with call detail records from every cellular provider in the United States, I have been involved with thousands of cases in which call detail records are obtained from these companies. Leading the way in the establishment of best practices within this field of investigation, I wrote and provided custom search warrants for every provider and distributed them to thousands of law enforcement officers in the United States, assisting them with the legal process of obtaining the vast and ever-growing amount of data sets offered by cellular providers. I have worked with the AT&T Global Legal Demand Center, GLDC, for over 15 years. I have firsthand knowledge that the AT&T GLDC is one way, not the only way, for law enforcement to obtain call detail records from AT&T. Yep, because the FBI can obtain what law enforcement can't through the GLDC. Now we're starting to get warmer. I have firsthand knowledge that there is another way to obtain call detail records from AT&T without going through GLDC. Yes, we all know. It's through the FBI, Sy. Yes, this isn't news. Over the course of many years, AT&T has had several different programs in partnership with federal law enforcement, primarily the FBI, that allowed for call detail records to be disseminated to the FBI without going through the standard GLDC process. Yep. And that's exactly how Moscow PD ended up getting a hold of the timing advance for the couple people that they did, was because they went through agent balance. The first AT&T timing report I was presented and had a chance to review and become familiar with was in August of 2021 and was obtained from AT&T through one of these programs, not through the GLDC. Yep, he already talked about that. I've been involved in numerous investigations where AT&T call detail records were obtained through these AT&T programs outside of the GLDC. Yep. I have firsthand knowledge and experience in working with individuals in AT&T associated with other programs. One such individual is Boyd Jackson. Mr. Jackson is a program director at AT&T who manages many other programs I am referencing. Mr. Jackson is the primary contact for the FBI when requesting records outside of the standard GLDC processes. Okay. So it says GLDC disseminating time in advance reports. The state is correct in their claim that AT&T GLDC did not provide law enforcement with AT&T time in advance reports until May of 2023. As a matter of fact, in May of 2023, the working group known as GLDC had only begun their storage of time in advance records. The first official release of AT&T time in advance data was not provided to law enforcement until June 15th, 2023 by GLDC. He just admitted they didn't start the storage until May of 2023. This is crazy. Keep that in mind. In 2022, the FBI obtained AT&T time in advance records from another source outside of GLDC. Okay, so now he says AT&T time in advance records in the state's possession. During this investigation, law enforcement obtained the following AT&T time in advance data. 2 of the victims had AT&T phones. Law enforcement obtained AT&T timing data on both of their phones. Law enforcement developed an early investigative lead in the case. That person had an AT&T phone at the time of the crime. Law enforcement obtained his AT&T time in advance data. Law enforcement also requested a tower dump consisting of AT&T timing advance data. This request involved AT&T providing all of the connections between 2 specific cell sites in Moscow during a 2-hour period. The data produced was AT&T timing advance data. In all, there were over 3,800 AT&T mobile phones identified in the timing advance tower dump. Yes, and guess what? That was requested through the FBI within the 7-day retention period. Right here, he says the AT&T timing advance data was obtained by the FBI using the internal source. Mr. Boyd Jackson, who is not associated with the GLDC working group. GLDC was not used to obtain this data. Yeah, no shit, Sherlock. A forensic examination of the AT&T advance records in the state's possession show Mr. Jackson's association with the reports. Of course, because they were obtained through Nick Balance going through the FBI and talking to Mr. Jackson. But what Sy is leaving out, and it's a big thing he's leaving out, is that there was a 7-day retention period. That's why they were able to get those timing advance for the 2 deceased, the 1 suspect, and the tower dump. They did it within 7 days of November 13th, 2022. Oh my God, this is so frustrating because he's completely misrepresenting this, even though he's trying to claim the state is who's misrepresenting things. It says there is work product in the state's possession created by the FBI, showing the AT&T timing advance data was not only obtained, but regularly referenced and used in the course of this investigation. The existence is well known to the investigation and prosecutors. Yes, you just said that. They obtained data for the 2 deceased, the 3,800 in the tower dump, and the 1 lead that they had. Unless he's trying to say here that they did receive Kohberger's time in advance, but that's not what he's saying here. He's saying that in their work product, we know they obtained the time in advance for those people within the 7-day deadline. So he's being so misleading. Chain of custody. The state has provided a certificate of authenticity to the defense in relation to the timing advance records described above. The COA was created in April of 2024 and issued by Director of GLDC Stephen Gordon. I have previously worked with him, and I am familiar with Mr. Gordon. Well, whoop-de-doo. Big deal. The COA specifically states, I am qualified to authenticate the record attached. Herefore, because I am familiar with blah, blah. You know what? I read that already. I have personal knowledge that in the event Mr. Gordon was required to testify, he would clarify that prior to May of 2023, neither he nor the AT&T GLDC working group was involved with AT&T time in advance records. Yes, because that is true. So of course he would say that. Additionally, there is forensic evidence contained within the records that indicate they were not produced by AT&T GLDC, nor were they produced in the year 2024. Well, yeah, okay. Yeah, that data would be what we talked about that was obtained through the FBI. In reviewing this data, I contacted and communicated with Mr. Gordon to clarify the chain of custody related to these records. Mr. Gordon and an AT&T legal representative informed me that Mr. Gordon would not be the individual to certify those records if required to do so, despite issuing the C of A. Well, of course, Mr. Gordon would not be the one to issue that C of A for the FBI records that came through the other department. I mean, this is common sense. He's not telling us anything that is earth-shattering here. In my review of this information, there is evidence to suggest the chain of custody involving these records and C of A were produced well outside of AT&T's normal practice. Duh, because they went through the FBI contact. There is missing information and data associated with this request. Not that it sounds like. The prosecution's prior claims that AT&T timing advance data did not exist in 2022 further complicates this issue. It is my expert opinion that any testimony proffered on behalf of the FBI and AT&T on this matter would clearly reveal those issues. Well, no, it wouldn't reveal any issues because one division is the GLDC, the other is who the FBI goes through. And they've made it very clear that the timing advance records they got were through the FBI contact, but they were within the 7-day window for record retention. So now he's saying evidence in direct contradiction to the state's motion. In my review of this investigation, I have read numerous emails sent and received by law enforcement pertaining to their investigation. One such email, dated 11/15/2022, was sent to Prosecutor Ashley Jennings at her Latah County government email address. Now, this is the one referenced in the defense's objection. This email is from Moscow Detective Lawrence Mowry. Excuse me. The email is informing Ms. Jennings of Detective Mowry's recent contact with the FBI Special Agent Balance. S.A. Balance informed Detective Mowry that AT&T can provide timing advance data and to make sure it is listed in the search warrant. Detective Mowry is specifically asking Prosecutor Jennings to make sure the AT&T timing data listed in the warrant prior to the report ever being distributed by the working group known as GLDC. Mrs. Jennings did respond to Detective Mowry's email inquiring on the specific verbiage needed to obtain the AT&T timing advance. This email is abundantly clear evidence that Ms. Jennings was not only aware of the existence of AT&T timing advance in 2022, but also shows her intention to obtain it through legal processes from AT&T. Yes, and guess what? If you already read back through the other documents as we went through them, those warrants were submitted to S.A. Balance to submit through the FBI contact. Okay? They did not go through the GLDC. They went through the FBI with these warrants. And you notice the date, November 15th. That was within the 7-day window for getting timing advance records through the FBI contact. So there is no contradiction in the state's motion. And I don't even know why he's saying there is. This email communication with Prosecutor Ashley Jennings is the same Prosecutor Ashley Jennings who filed the current contradictory motion stating AT&T did not produce timing advance records in 2022. It's not contradictory, and she did not say they didn't produce timing advance in 2022. She said the GLDC did not. This guy is lying through his teeth on an affidavit. There is clear and convincing evidence that not only was the FBI able to obtain AT&T timing advance records in 2022, but they did so with knowledge of the prosecutors involved in this case. Yes, right there. Was the FBI able to? Yes, they went through the FBI. But again, he's leaving out the 7-day retention period. Oh, good Lord. Oh, good Lord. Missing AT&T timing advance. In my review of this investigation, based on my training and experience, it is incredibly unusual that the defendant's AT&T timing advance records were not obtained by the FBI. Well, that's because they tried to get them after the 7-day retention period, you dumbass. The FBI demonstrated their ability to obtain the timing advance in November of 2022 by obtaining AT&T timing advance records on over 3,800 mobile devices, none of them being the defendant's. Yeah, I wonder why. That's because it was within the 7-day window. When it comes to location, I'm sorry, I shouldn't, I'm laughing with amazement that he's literally lying on this. When it comes to location data from AT&T timing advance data can be some of the most accurate data available. Additionally, it contains connections to the network other than the typical voice, text, or data connections. This allows law enforcement to not only see more data, but more accurate data anytime the defendant's locations are in question. A timing advance report would be asked for as a standard operating procedure. Yes, they asked for it, but it was outside the window. Moscow Police Department, by way of the FBI, with the knowledge of the prosecution, demonstrated their awareness of this standard procedure when they obtained the AT&T timing advance data on over 3,800 mobile devices. And again, he's leaving out the fact that those were requested within 7 days of November 13th, 2020. When detectives and prosecutors requested and served 2 different search warrants to AT&T on the defendant's AT&T account, they requested the exact same timing advance records that they previously did when they obtained the timing advance data from AT&T on over 3,800 devices. They also maintained the same process in utilizing the FBI to serve the legal demands on AT&T. There is no difference in the verbiage, legal process, or individuals that produced the AT&T timing advance on the 3,800 mobile devices and the request for defendant's AT&T timing advance data that allegedly yielded nothing. Yeah, there is a difference. You know what the difference is? The date. December is a little different than November when you only have a 7-day retention period. Additionally, on December 23, 2022, the FBI sent a communication directly to AT&T, specifically detailing their request for the defendant's AT&T timing advance records. There is no reason to believe AT&T would not respond to this request. Yeah, they did respond to the request, and they sent all the records except for the timing advance. And that's because it was outside the 7-day retention period. It is my expert opinion AT&T timing advance data did exist for the defendant's AT&T mobile device in 2022, but it was requested from AT&T by the investigators, and it was requested by the investigators involved in this case. Well, yes, it was requested, and yes, it would have existed had they requested it by November 20th. The investigators previously demonstrated their ability to obtain the timing advance in 2022. Yes, because that was requested in November. Failure to produce the defendant's AT&T timing advance data is either a gross deviation from standard practice or intentionally withheld from release in discovery. Well, guess what? It's neither. It's neither one, Sy. There is overwhelming evidence showing the state obtaining and using AT&T timing advance data in the course of this investigation in 2022 on over 3,800 AT&T mobile devices other than the defendant. Again, those were requested within 7 days. There is no doubt the author of this current motion, Prosecutor Ashley Jennings, knew or should have known AT&T timing advance data did exist in 2022. Yes, she knew that. She was directly involved in the legal process obtaining it and was aware of the work product created from it to further the investigation. The current motion is a deliberate misrepresentation to the court to further conceal false statements used to obtain probable cause against the defendant and conceal exculpatory evidence from discovery. Yeah, that's a load of hogwash, Sy. I've circled these next couple paragraphs because I cannot believe the self-righteousness and the fact that he is purposely misleading in this, but yet accusing the prosecution of being misleading. He says, I'm prepared to provide witness testimony and relevant exhibits that support all my opinions contained in this affidavit. It is my belief this evidence is beyond clear and convincing and will be supported by any competent expert in this field who reveals all the data. This is not a battle of experts. Well, yeah, actually, Sy, it is. The evidence supporting the opinions in this affidavit is overwhelming. Jesus Christ. In nearly 30 years of working with and for prosecutors all over the United States, I have never witnessed such a deliberate attempt by prosecutors to mislead the court on evidence in such plain sight. Anyone making such a claim would have to believe the court is incapable of reviewing physical evidence in possession of the state and defense. It rises to a level beyond simple miscommunication of oversight and is, to a level beyond simple miscommunication or oversight and is clear and intentional misrepresentation in the hopes to conceal a much larger issue. I respectfully request the court give this affidavit the due attention it deserves and explore these issues further. Yes, I hope Hippler does give this affidavit the attention it deserves, because this guy needs to be torn a new one for purposely misleading and lying on an affidavit. Not once in here did he mention the 7-day retention period, and that was why they were not able to get Kohberger's records in December. They could no longer get those timing advance by the time they knew Kohberger's name. And he keeps bringing up the 3,800 from the tower dump and all that. That's because those were requested before November 20th. I don't understand what he thinks he's going to gain by lying in this affidavit, but it is absolutely ridiculous, and I cannot wait for Hippler to tear the defense a new one over this. So in summary, Ashley Jennings never said AT&T did not produce timing advance records in 2022. She said they did not produce them through the GLDC in 2022, which is correct. No one said the FBI could not obtain AT&T timing advance records through the FBI connection. Those records could be obtained, but only within 7 days due to the retention period in 2022. The 3,800 cell records received from the tower dump, along with the AT&T timing advance records of 2 of the victims and an early suspect, were all requested by the FBI prior to November 20th, 2022, which was within the 7-day retention period. That's why they received those records. Brian Kohberger's name was not known until December 19th, 2022. The warrants requesting his timing advance records were not submitted by the FBI until December 23rd, 2022. That was well after the 7-day retention period. Therefore, no timing advance records were received. The state does not have timing advance records for Brian Kohberger for November 13th, 2022. They are not withholding exculpatory evidence.